Welcome to our two-part webinar series on being American and the history of anti-Asian laws. This webinar is a talk on citizenship as architecture, where we have three legal scholars review how citizenship was constructed on this land we call the United States of America. For those of you who don't know, OCA is currently in a lawsuit represented by the Washington Lawyers Committee and Asian Americans Advancing Justice, AAJC, to protect birthright citizenship. We hope that this two-part webinar series will help educate our members and audience on the concept and history of citizenship in this country and why such lawsuits are important. Our scholars on this webinar will speak to some important legal cases from the past, share their thoughts on inclusion and citizenship in America's democracy, and at the end, there will be some questions from the audience. Since we were unable to record the introduction on the panel itself, I'm here to introduce the three speakers we have for this webinar. First up, Professor Robert S. Chang is the UC Irvine School of Law Executive Director for the Fred T. Korematsu Center for Law and Equality. Professor Chang is the inaugural chairholder of the Sylvia Mendez Presidential Chair for Civil Rights. Professor Chang founded the center, named for pioneering civil rights hero Fred T. Korematsu, in 2009 at the Seattle University School of Law. The center leads numerous initiatives and projects focused on research, advocacy, and clinical education. You can learn more about the Korematsu Center in the link in the description box below. Professor Chang is one of the nation's leading scholars on issues of race and interethnic relations and one of the most recognized voices on Asian Americans and the law. He is the author of Disoriented, Asian Americans, Law, and the Nation State, and Banned, The Fight for Mexican American Studies in the Streets and in the Courts, which came out last year. Next, we have Professor Hiroshi Motomura, who is a teacher and scholar of immigration and citizenship, with influence across a range of academic disciplines and in federal, state, and local policymaking. Professor Motomura has testified in the U.S. Congress, served as co-counsel or volunteer consultant in many litigated cases and policy matters, and has been a member of the American Bar Association's Commission on Immigration. In the fall of 2008, he was an outside advisor to the Obama-Biden transition team's working group on immigration policy. He served on the board of directors of the National Immigration Law Center from 2011 through 2020, and he is one of the co-founders and current directors of the Rocky Mountain Immigrant Advocacy Network. Professor Motomura's latest book is Borders and Belonging: Toward a Fair Immigration Policy, published by Oxford University Press earlier this year. He is also the co-host of the podcast series Unsettled: Immigration in Turbulent Times, which examines Trump administration policies and actions affecting immigration and migrants and their communities. For his collaboration on an overview of a U.S. immigration law in a completely different medium, see the Try Guys, Try Immigrating to America, which we'll also link below. Last but not least, we have Aziz Rana, professor of law at Boston College Law School, where his research and teaching centers on American constitutional law and political development. In particular, his work focuses on how shifting notions of race, citizenship, and empire have shaped legal and political identity since the founding. His first book, The Two Faces of American Freedom, situates the American experience within the global history of colonialism, examining the intertwined relationship in American constitutional practice between internal accounts of freedom and external projects of power and expansion. His recently published book, The Constitutional Bind: How Americans Came to Idolize a Document That Fails Them, explores the modern emergence of constitutional veneration in the 20th century, especially against the backdrop of growing American global authority and how veneration has influenced the boundaries of popular politics. We hope you enjoy the webinar that follows and the part two, Paperwork as Power, which is also on our YouTube channel. First, I'd like to start with you, Hiroshi. Your work argues that the American immigration and citizenship law has long relied on a divide between formal membership and functional belonging. Looking back at the 1790 Naturalization Act, how do you see this tension between legal inclusion and lived exclusion continuing to structure immigration and citizenship policy today?
Well, thanks for the question. I'll try to give an answer which I think amounts to an introductory overview to some things that I think Bob and Aziz will address as well. But I think, asking about the tension between legal inclusion and lived exclusion is probably fundamental to thinking about citizenship as architecture. There's clearly a big difference between legal inclusion and lived exclusion. And so let me address citizenship in that context. And I'm using citizenship as a way to think about legal inclusion, people who are legally included and have their membership recognized. I guess we call them citizens in the modern age. So I'll address citizenship, but I just want to also note that there are many other ways of including people legally. I mean, there are people with green cards or lawful permanent resident status people. There's lawful non-immigrants, and even if their status is temporary. There are people in an in-between status, like temporary protected status or DACA, other people, and then undocumented people can be legally included in some ways. For example, access through K through 12 public education. So I want to, alert us to the spectrum of ways that we can be legally included. But I want to focus on citizenship. And the reason is that citizenship really matters, right? In a couple of ways. One is some things that are probably familiar to us. I mean, citizens, generally speaking, citizenship is required to vote. Not 100% actually, but that's often one of the things that people cite when they say, "What can citizens do that others can't?" I also want to point out that citizenship, as long as you're a citizen, you're immune from being deported. That's huge. But really, citizenship has a more fundamental significance, and that is that if you're not a citizen, then you could be treated um, less well, put it that way, as citizens. And the law, and one of the things that citizenship law does is it normalizes treating non-citizens worse. We kind of, kind of don't think about it that way sometimes, but we just sort of take this article of faith that citizens are advantaged. And so that's why citizenship matters. It allows you to stand up in certain ways that you would not be allowed to, and it allows you to demand certain things or that you would not be allowed to demand. So I think if you think about the citizenship as legal inclusion, I think it comes down to, I want to flag four questions that have historically really mattered. You mentioned 1790 Naturalization Act, but and I'll include that in my answer, but let me identify four questions. These aren't the only four questions, but I think they're really worth asking. One is, when has citizenship or legal inclusion been denied? Another is, when has citizenship or legal inclusion been taken away from people? The third question is, when has citizenship not been enough for lived inclusion? When has citizenship not been enough for lived inclusion? Um, and another is, when and who doesn't need to be a citizen to be included, right? So um, I will get to each of these, and and I don't think those will be in the exam, unless you're watching this for a class, I suppose. And some of these examples historically might be familiar, but I think it's really worth seeing them as an example of an overall arc of history. When has citizenship been denied? Well, the 1790 naturalization statute limited the acquisition of citizenship after birth. It limited it to, you can only become a citizen if you were a free white person, and that was written into the statute. It's only in 1952 that racial bars end. And even after that, you have more subtle forms of denial because you can't become a citizen, generally speaking, if you're not a lawful permanent resident. And there are a lot of barriers that I think are actually quite racially based to becoming a lawful permanent resident. And that's just on citizenship in terms of naturalization. Of course, the history of the United States includes many infamous examples of denial of citizenship on the basis of race, most infamously to African Americans in the Supreme Court decision in Dred Scott in the 1850s. So that's citizenship has been denied, but it's also been taken away. And I'll give you some examples of this. People have lost their citizenship in the 20th century based on marriage to non-citizen men. Women have lost their citizenship. Um, Another is denaturalization. Denaturalization is something that has run through American history, and I think we're seeing the Trump administration taking it upon themselves to focus on naturalization cases and to take citizenship away from people. Um, and that's been something that they've put a lot of energy into. I also want to point out to the 2025 executive order redefining and narrowing who was born a citizen. It does that in a very significant way, and by taking away citizenship, or not recognizing citizenship if you had, unless you had a citizen or a lawful permanent resident parent. In other words, if you were born in the United States and your parents were working here, there were students on a F1 or J1 visa, then it says you're not a citizen. The executive order says it applies only, it will only be applied into the future. But in fact, the executive order is not actually limited in that way. They say they can implement it into the future, but it would actually redefine citizenship. That's a way of taking away citizenship too, if it's fully followed through. Um, Third question, so that citizenship being denied, that citizenship being taken away. And then the third question is, when has citizenship not been enough for lived inclusion in this country? And of course, there, unfortunately, throughout American history, many examples of this. I mean, the civil rights movement is really a statement that we might be citizens, but we're not included. We're not included, even though we're citizens. There are many times when another example is the incarceration of Japanese Americans during World War II. Many of those incarcerated were U.S. citizens, but citizenship did not guarantee their inclusion at all. Um, and another thing, which I'll also, I mean, you may notice I'm using examples partly from history, but also from 2025. Today, there are immigration raids, and there are plenty of people who feel that even though they're U.S. citizens, they need to carry their passports with them at all times because of the racial profiling enforcement that's been basically approved by the U.S. Supreme Court. And so citizenship is not enough for lived inclusion in those instances. Let me go to the fourth question, which is when has or who has not needed citizenship to be included? Well, a lot of this is, I'll give you an example of this. We think of now as the citizenship as the thing you need, and then you can, argue about how included you should be. But there was a time when the United States history treated European immigrants, even from the first day they were here in this country, as if they were citizens. They were treated much like citizens because they were seen as intending citizens, as future Americans or Americans in waiting, and that's an interesting thing too because that's the other side of the coin. Citizenship not being included, not being needed for lived inclusion. Okay, so let me just close by identifying some fundamental themes that run through this because I think they're very important to keep in mind. One that I mentioned in several of my examples is race and exclusion, and thinking about citizenship and immigration status on the basis of race as an exclusionary tool or marker. The second thing is that national security has run through this history, often the invocation of national security and the association of national security threats with race or national origin. And we see this today. And there in a lot of ways, but I think one of the things we're seeing now is narrowing by the administration of who really belongs. And I think that's being propagated by the narrative that immigrants are invaders. There's so much invasion narrative. I mean, there's so many invasion times the word invasion is used in executive orders. The last two things, I think it's worth thinking about the purpose of citizenship because I think in this modern era, there's a tendency to view citizenship as some kind of a reward or diploma for some recognition of what you've done in the past and what you may be now. But it's not really seen anymore as a vehicle for including people and for building a community and building society. And I think that's unfortunate because there's such a begrudging granting of citizenship in a way that with fees and tests and things like that, instead of using it as a way to build community. Last point, the idea of citizenship as a vehicle for inclusion, it really does look to the future. I think it's important to really think about time here. The exclusion or the exclusion of history has really mattered. I think one of the consequences of exclusion based on race, is essentially to marginalize those communities for generations. And we still see that today, even though it's been well over 100 years or longer, really, in a way, since the founding of this country for this phenomenon. Okay, so anyway, let me just stop there. That's just kind of teeing up a lot of questions, I think, more than anything else.
Thank you, Hiroshi. And I think the present day ties are true. My family has a nail salon in Houston, and actually every single nail technician has started carrying their passport on them, and they're all U.S. citizens. They have the U.S. passport, but because of what's been going on, that is a reality that many folks in our community have started practicing. Aziz, I want to turn to you. You've written about how U.S. freedom has historically been built on exclusion, where self-rule and expansion depended on defining who stood outside the political community. How do you see laws like the Chinese Exclusion Act and other racial prerequisites shaping not just who could enter the nation, but the very idea of but how the very idea of American democracy was defined?
Yeah, no. Uh, my thinking about this has really been informed by Hiroshi's work, and especially by the book Americans in Waiting that Hiroshi mentioned. In fact, when I was working through some of my own ideas about American freedom, I shared a bunch of that material with Hiroshi, and it had a huge impact on my own thinking. And so, in a way, this is a gloss on, or this is a presentation of some stuff that I've come up with, but very much indebted to arguments that Hiroshi's made. So, in my own work, I've contended that the best way to think of early American constitutional development is as a very particular experiment in what I've called settler empire. And what I mean by this is that Anglo Europeans brought over from Europe, and especially from England in the 17th century, an incredibly rich account of republican freedom. So, this was the idea that in order to be free, you had to have control over all of the conditions of your collective life. And so this is like spiritual independence and freedom, but economic independence, political participation. And this was a society, if you think about these small colonies on the eastern seaboard, that was pre industrial, agricultural, and at the heart of the idea of enjoying something like economic independence meant that you had to have access to land. In other words, you needed to be a property owner and you had to have a relationship to land in which you not only enjoyed control over it, you could engage in something like self directed work. Now, the thing that was pretty apparent almost immediately, if you think about it, is that, well, in order to ensure that insiders that had engaged in settlement, so settler insiders, enjoyed the benefits of this access to land and economic independence, well, you needed to have it broadly distributed. And so almost immediately, it produces a propulsion to engage in territorial conquest. So to expropriate effectively indigenous land so that it could be broadly distributed among settlers to enjoy something like social mobility, economic independence. And at the same time, there was a second element, which is if you're in a society that's, again, pre industrial and agricultural, work itself is hard, labor is difficult. And there's a basic idea that there's a divide between the kinds of work that you can think of as free, as liberating, and the kinds of work that just might have to be done, but that goes hand in hand with a kind of coerced or harsh form of life and existence. And the way in which settlers increasingly solved this problem of the fact that you need access to land, so you're engaging in territorial expropriation of indigenous peoples, but then you're also going to need some folks to engage in work that's hard and difficult, is through effectively over time the use of enslaved labor. And so African slavery serves as a divide between free and unfree labor. So this becomes a solution to that kind of classic problem. And that the heart of collective life means that you have this internal practice of greater forms of independence, access to land ownership, self directed work, but it's grounded in a politics that requires both conquest and the coerced use of other labor, and that assumes that only for insiders do you enjoy something like political participation, where you actually, engage directly in the practices of self-government. Now, the other kind of key element about this is that what Anglo-European settlers realized very quickly, and this is where Hiroshi's idea of intending Americans or citizens in waiting comes into play, is that you're going to need more people than just the initial colonists in order to be able to sustain the society, in order to be able to engage in economic growth, to have as much territory as possible. And so what happens very quickly, and then becomes the policy of the first century of the US, are incredibly inclusive migration policies where the US border is effectively more a port of entry than anything like a harsh barrier that we might associate with contemporary immigration policies, but only for those that are viewed as fit to participate within the political community. And the way in which essentially Americans sort of solve the problem of who can be thought of as an insider is by effectively making the determination that we saw in the context of slavery that, well, if you have been consigned through practices like slavery, through harsh forms of work, then that's justified on racial grounds that say the very reason why you're consigned to this is because of claims about racial hierarchy. And then over time, that becomes a broader argument about how to enjoy something like American values, you have to have a very particular kind of ethno-racial profile. And that becomes a definition of who's going to have the benefits of these inclusive forms of migration policy that entails, for instance, allowing folks to become citizens relatively quickly, providing non-citizens access to voting rights, as Hiroshi has explored. And what that does is that in the 19th century, even before you really have the kind of federal immigration policy that we associate with contemporary life, you already start emerging practices of migration policy, movement policy, where movement is very easy for those that are included as members. For Euro Americans that are thought of as worthy of economic independence and political participation, you can travel across what effectively is a continent with multiple political communities, independent Native American nations that occupy the same landmass. While if you are a part of a community that's viewed as outside the terms of settlement and membership, you face incredibly harsh controls on your movement. And we can think of the forced removal of native peoples, things like the Trail of Tears that the Cherokee Nation faced. We can think of the fact that for Black Americans, that if you were not enslaved, you were not permitted to enter states with slavery. And even in places that banned slavery, to give an idea, the years before the Civil War, of the kind of controls on movement for folks that are viewed as outsiders. Oregon Territory, Illinois, Indiana, Iowa essentially barred entrance effectively by Black Americans. And in this way, what ends up happening at the end of the century is a debate effectively within Euro-American society about how to read Asian migration and the Asian American experience. And two of the dominant perspectives, so there's a minor chord that's committed to something like equal and effective freedom for all, and so genuine inclusion for folks regardless of race, but that is a very minor chord within Euro-American life in the later part of the 19th century. But the two basic perspectives are, well, we can think of Asian American inclusion, but on terms effectively of like a required labor force to engage in forms of work that are not viewed as free labor, but might be necessary for the society. And so some space for migration on those terms. And then in response, in the context of growing labor conflicts, an argument that no, actually you should have bans entirely on Asian American inclusion based on the idea that Asian Americans, based on these ethno-racial judgments, shouldn't be incorporated as part of the political community. And that becomes the basis for things like the Chinese exclusion laws, which is a ban of Chinese labor and is part of a harsh set of controls that get applied to Asian Americans exclusively. And we can think of it as the beginning stage of what becomes the federal immigration system. But at the same time, it's also noteworthy that in the later part of the 19th century, the beginning of the 20th century, it's for Asian Americans alone, because it's a piece of this broader story of how you control movement, whose movement is allowed to operate freely and whose movement is not. And it tells us something, I think, pretty profound about democracy, not just in the US, but American democracy certainly, which is we tend to assume that when we talk about democracy, that democracy is inclusive and universal. And yet, actually, the historical experience has been that democracy has oftentimes gone hand in hand with various forms of ethno nationalism, where you have rich accounts of participation, access to mobility, but for a racially defined subset of the population. And really, the struggle in the US and the struggle globally is the extent to which you can take seriously these principles, the principles of genuine self rule, but on terms that actually include everyone. And just as this was a problem in the latter part of the 19th, early part of the 20th century, so too today are we dealing with the same basic dilemma. Can we actually take seriously the principles as principles not just for some, but for all?
Thank you, Aziz. I think that is like that's a really great explanation, I think, academically and historically, because in our work in the civil rights space right now, we talk about how, you know, the Constitution and Declaration of Independence, everything grounded in essentially white supremacy. And many think tanks and civil rights orgs are working to build, you're hearing this phrase often, I'm sure our OCA members on this call are familiar, working to build a multiracial democracy. And I think that's trying to address what you have just shared, right? Turning to you, Bob, in your work on Korematsu and its legacy, you've emphasized how courts' deference to executive power under national security has enduring consequences. And we're seeing that play out right now today with the comeback of the China Initiative, things like that. So it's despite its formal repudiation, what aspects of that logic of racialized suspicion and emergency authority do you still see at play in contemporary law and policy as well?
Sure. So I'm going to begin with a very short answer in terms of the question of the sort of formal overruling of Korematsu in Trump versus OY in the travel ban case. So in the travel ban case in 2018, the U.S. Supreme Court, Chief Justice John Roberts said that Korematsu was gravely wrong the day it was decided, that it has been overruled in the court of history, and that it has no place under the Constitution. So even though there's been the formal repudiation of Korematsu, what we have, though, is still the constitutional architecture in terms of what might be described as national security exceptionalism. And so part of the idea there is that when we're thinking about our Constitution and whenever national security gets invoked, we have a different set of rules that apply. Now, in terms of thinking about the sort of overarching theme of this webinar, citizenship as architecture, which is located for me in terms of thinking about our Constitution and the rules that it creates in terms of inclusion and exclusion. And so I also want to, I hope that we're going to expand the way that we think about inclusion and exclusion to go beyond thinking about citizenship. Citizenship is, of course, critical. But when we think about inclusion and exclusion, I think we do need to think about how we treat non-citizens who are members of our political community, even if they're not formally citizens. And so when we think about sort of the rise of the national security constitution, national security exceptionalism, when a different set of rules apply in terms of how our courts view the actions of our political branches, the National Security Constitution actually emerges out of Chinese exclusion. And so Aziz mentioned the Chinese Exclusion Act, and that's what the political branches did in terms of saying that there are certain people who we won't even allow to enter into our country. But in terms of the role of the courts in permitting that kind of racial discrimination, there's a case in 1889. It's sometimes called the Chinese exclusion case, Che Champing versus the United States. And it had to do with the ability of Congress to create to say that Chinese persons who had entered into this country, who secured papers that would allow them to return to this country after visiting China. Congress in 1888 said those papers are no longer valid. And so then the court had to decide, well, what do we do with this person, Chi Jinping, who followed the rules, who had lived in the United States for 12 years before going to China and tried to return to the United States, having this paper in his hand. And the court had to decide, what do we do with that? Now, in that case, emerges a doctrine that Hiroshi has written a tremendous articles about, which is the so-called plenary power doctrine. And so in this area, with regard to our constitutional architecture about the control of the border, what we find is that even though we're told a story in terms of con law, constitutional law, that our courts are there to check the excesses of the political branches. But with regard to the border and policing of the border, the rules that are created around the border, the idea of plenary power comes about. And in that case, the US Supreme Court said that if Congress decides that a group of people are a threat to our nation's security, that their decision that they cannot enter into this country is final upon the judiciary. So let's think about what that means. So their determination is final upon the judiciary, which means that the judiciary has to stand down with regard to any challenges that are there. So with regard to the border and this idea of making sure that national sovereignty is preserved, what we have then is national security. The border becomes a national security issue, and that gets carried forward so that Congress can decide to require papers for Chinese persons who are legally here, who have to present evidence from one credible white witness. Otherwise, if they don't have this paper, they can be deported. Deportation is not considered to be punishment. And therefore, all of the other protections that we might see come about with regard to punishment are not at play. And so we get courts having a limited role, national security, and this gets carried forward ultimately in terms of Japanese American incarceration. Although before Executive Order 9066, I think it's critical to include that President Roosevelt invoked the 1798 Alien Enemies Act. That was the first step, actually, in terms of eroding the rights of persons who are legally here. And then once that infringement took place, the executive order permitted then the exclusion of Japanese Americans, and they called it evacuation, the evacuation of persons of Japanese ancestry, alien and non-alien. And think about the word magic of that, alien and non-alien. What is a non-alien? A non-alien is a citizen, but they didn't want to say that. And so what we have there is, through the words, where even citizenship, as Hiroshi said, wasn't enough to protect persons of Japanese ancestry. But critically, when we think about the treatment of persons based on ancestry, we're also told this other story about equal protection. People are to be treated equally. And as a technical matter, the 14th Amendment, Equal Protection Clause, only applies to the states. And so in the case that came before Korematsu, Hirabashi versus the United States, Chief Justice Stone said that with regard to curfew, it's important to recognize that the federal government is not bound by the Equal Protection Clause. And so then they didn't even reach the question of equal protection in that case. The Equal Protection Clause only began to apply to the federal government in 1954. And so when we're thinking about the context for the sort of the overturning formal repudiation of Korematsu, it's formal, it's in name only, and everything that was in place before in terms of immigration exceptionalism and national security exceptionalism remains in place. And so then when we think about how or why this is important today, well, that architecture is set, and it's applying to things like what Hiroshi talked about, the roving ICE patrols who are using racial profiling, to the termination of protected status for Venezuelan immigrants, and labeling so-called members of a certain Venezuelan gang to be alien enemies, which subjects them to mass roundups and deportations with very little process. So let me just stop there.
Thank you all. And I see some reactions. So if at any point you guys want to jump in and build off each other's points, please do so. But actually, I know I had a couple more questions, but there's an interesting question in the Q&A right now for you all about state efforts. And I am familiar with Karthik Ramakrishnan and his book on reimagining citizenship, utilizing states' rights, or kind of flipping states' rights, which was initially kind of a more infrastructure to protect slavery, and flipping that around. You see states like California trying to use states' rights to leverage its authority to protect immigrants and sanctuary cities, things like that. And the audience member, Abraham, is asking about state efforts right now to restrict immigration in support of this current administration. Do you anyone want to comment on the use of states' rights? Because I think your conversation right now has been at a federal level. What are your thoughts on the states' rights framework in terms of citizenship right now?
You want to call on one of us?
Aziz, I know you saw Lou,
Yeah.
you look like you have a
So
reaction. Yeah.
yeah, so I'm happy to jump in. So
Yeah.
my view about this is that if we're thinking about just like a first best way of organizing a political system, the one that we currently have just isn't it, which is like we have a system that emphasizes not a principle of one person, one vote in our electoral democracy, but the geographic unit of the state. And like the state as a geographic unit ends up shaping all of the forms of representation. It shapes the Senate through the capacity of the states to determine gerrymander districts. It shapes the House of Representatives through the Electoral College, who's the president, to the president and the Senate, who ends up on the Supreme Court. And what this has done, I think, is precisely because of how geography has become a mismatch for like the cultural and racial diversity of the country. It's meant that one of the two political parties is dramatically overrepresented and is in a much better place to be able to dominate national politics, even if that party doesn't have something like a meaningful majority. So now, with that as a reality, you have a situation where at present, it means that to the extent that you might have folks that are supportive of immigrant rights at the state level, then the tools that you might have available to you because of the size and diversity of the country are tools at the state level to protect those that are most marginalized. And so I would say, under those circumstances, the activities that we're seeing at the state level from state AGs, from state politicians, because they're responsive to a different kind of underlying political base, especially in some parts of the country, these are things that should be, should be lauded. But at the same time, they're ultimately I think of them as necessary defensive maneuvers because of the broader problems of the constitutional system. And as the question suggests, in a context in which you can't assume that they're going to be a generally applicable solution. So that for every California, there's going to be a Florida and a Texas, so that where you'll have state actors actually intensifying precisely the kind of discretionary violence that you're seeing from the federal government. And so this suggests that it's essential to use the tools, the legal tools that are available, but ultimately those tools have to be part of some kind of national majority coalition that can address the problems of our electoral system so that we can have a very different comprehensive response.
Thanks, Aziz. Hiroshi, do you have anything to add on that?
Yeah, I think I can add a bit to what Aziz is saying, and this ties some things that I think both Aziz and Bob were talking about earlier. I mean, here's my take on what's going on and how state and local decision making matters, because of course a lot of it is more inclusive and a lot of it is exclusionary, right? The question focuses on exclusion or restriction by states, but we've also got not just sanctuary cities in the sense of protecting against enforcement, but those sanctuary cities are not just sanctuary cities, they also provide driver's licenses and in-state tuition and really try to in healthcare and include people. So I'm going to go back to what Bob was saying about national security. I think, and I guess it picks up on what I was saying earlier about invasion. I mean, I think that what we've seen in the last 25 years or so are migration movements that have that we've been unable to deal with. Our immigration system, and around the world is unable to deal with it because it's a system that's about at least 100 years out of date. And so we funnel everyone into the asylum system. We require people to get to the border to apply for asylum. When people get to the border, then you've concentrated the problem in a particular place, and all of a sudden you have what some politicians can call a border crisis, and then that quickly leads to the narrative of invasion, which is what you've seen here. And so some of the things that I'm seeing in the webinar chat about sort of having to carry passports and stuff, it really reflects the fact that all of a sudden this invasion narrative is really taking over immigration policy, and it really allows the federal government to go into a place like California and say, well, we can do in downtown Los Angeles the same thing we can do on the border. And it's really striking that when one of the Justice Kavanaugh defended allowing racial profiling, he cited a case that speaks to what the federal government can do at the border. So anyway, so now the border is in downtown Los Angeles. So why does this relate to the question, or how does it relate to the question? Well, in Los Angeles, I think you're seeing a lot of people standing up and saying, this is not a matter of invasion. This is how we build our community here. And we want it to be inclusive in a way that I think this picks up on another thing that Bob said. We want it to be inclusive in a way that is not just citizens, but people who functionally are part of the community. So that's what you're seeing, in a place that in many cities around the country. And then to get out of the question, then the flip side, I think you're seeing community building take place in a very different way in some other states, and saying, well, we think it's okay if we engage in certain kind of police practices and things like that. So what you have here is a federal government that is trying to tamp down, suppress any kind of a community building in an inclusive way, and to empower the kind of community decision making that says it's okay to exclude people. So, that's kind of thinking about what's going on in 2025, and I think it ties in with the rhetoric of, people from Venezuela are going to be deported, under Alien Enemies Act and stuff like that. I mean, in a perverse way, it all fits together.
And so, if I could just add, before the Civil War, a number of northern states passed what were called personal liberty laws, and they were intended to protect Black freed persons in the North from slave catchers who were acting based on the federal Fugitive Slave Act. There was a case in 1842, Prigg versus Pennsylvania, where the U.S. Supreme Court invalidated those personal liberty acts that were passed by the northern states. And so we have states' rights there, in some ways, being overcome or overridden because of the imperative of slavery. When I think about what might happen today, when I think about states like California, when we think about issues that like Hiroshi raised, challenges to in-state tuition being given to undocumented persons, things that are intended to be protective, things that are in some ways analogous to personal liberty laws. My prediction is that this court is going to say no to these protective things, and that they will say yes to the restrictive actions that Hiroshi discussed. I'm very saddened by that. But in terms of whether we can rely on our courts to allow states to be more expansive in terms of inclusion, I'm skeptical of that. And that's why the political realm is so important in terms of if we're going to bring about change.
Thank you. And I just want to remind our audience, although I know we have like about 10 minutes left, if you have any questions for our panelists, please feel free to do so in the Q&A or the chat. But as we start to wrap up, I think this segues nice into some of our final questions about, I think I will go with, how does revisiting the history of exclusion help us reimagine citizenship as a more inclusive and democratic practice today? Or perhaps as legal scholars, um, how what words, wisdom, or advice would you give to the civil rights groups right now who are trying to, rebuild a multiracial democracy, and all of our advocates on the call right now? Let's go around there. We'll start with you, Hiroshi.
Well, I mean, to be succinct, citizenship, or I should say, legal inclusion, recognition, having your membership in society recognized, that's not recognized for many people who actually belong here. So, in other words, if you want to use another term than citizenship, but that type of formally recognized membership, the ability to stand up and to be protected, that's not granted to it. That's not recognized for as many people as it needs that need to be recognized. That's very clear. And I would not even tie that to legal status in many cases. I mean, this is really an argument for legalization. That's one. Not enough people have citizenship and the second piece is that for those who have it, it's not enough. And history is full of examples of this. And so, the society that I imagine is a society where that kind of recognition is much more functionally granted to contributions and membership in society, and not just to the dominant culture, but to any communities inside this country. And the second thing is that when you have that, it means something, not just that you can vote, but that you have, on the basis of citizenship, access to the things that should promise.
Thank you. Bob?
So I worry that we are too often being reactive rather than being proactive in terms of imagining a more inclusive America. Now, part of the problem, I think, is the way that history is taught. Uh, in a lot of our amicus advocacy, we try to engage in narrative change, telling history to the courts, but also telling history as a public document. And a lot of times we lean into what we think are the lessons from history, where we look at what we did in the past and it's like, gosh, that was terrible. We should do something different because if we do the same, like that was really bad. But I fear, though, that during this political moment, that those things that I think were bad or that I think are obviously bad are sometimes thought as, oh, that's the America that we wanted. We want the America that looked like what it did before. I'm reminded of the 1921 Immigration Quota Act that set immigration quotas as a percentage based on a multiplier of the 1910 census. 3 years later, they did the 1924. They did a different act, and they said we actually like what America looked like in 1890 more than in 1910 because too many undesirable people had come in during those intervening 20 years. And so those exclusionary acts, looking to the past, there's this nostalgia in some ways for the America that once was, which for many of us, we think is not the inclusive America that we want. And those are the stories that we tell to try to bring about greater inclusion. But there are others who believe, well, that's exactly the problem. Immigrants are the problem. They are the enemy within, and we need to respond appropriately.
I always trust when there's a call with all lawyers that there is a balance of optimism and realism. I appreciate that, Bob, because I think we recognize that, and as a civil rights try to balance those two narratives a lot, or the reality of the other narrative. So Aziz, up to you. You can be realism, optimism, because I'll close out the
I'll
call.
do
No worries.
I'll do both, which is to say that I think, the thing that both Hiroshi and Bob have really emphasized, which is key, is that it's not like if you get into this bucket of citizen, then all of like the rights and opportunities go hand in hand with it. Like that American history is a much more complicated one where if you're a European non-citizen, you had more rights and opportunities than many people that were formally citizens in the US, but were indigenous or Asian American or Black American or Mexican American. And I think, in a way, the complexity of that story, what it might push us to do is to think about different kinds of parallels and analogies. Like, if I think today about the immigrant experience, especially that of undocumented immigrants, but more generally, I think in many ways, some of the best parallels is to the story of Jim Crow in the latter part of the 19th, the beginning of the 20th century. Like we tell a story about Jim Crow as well. That's not the same as the immigrant experience today because Black people were citizens and also because we tend to focus on segregation, like the formal separation of folks. Where Jim Crow was also pretty profoundly a system of labor, which was an effort to be able to sustain and control a labor supply of Black Americans and to do so in the South while also limiting the capacity to enjoy meaningful political and other kinds of legal protections that would contest that emergent system. And if you think a little bit about how immigration policy operates today, that we have millions of undocumented and documented immigrants who engage in the necessary but oftentimes difficult forms of work that are crucial for the maintenance of our economy, but under conditions in which they're systematically denied meaningful legal rights, from labor protections to living effectively in a constant state of probation, where even if you have formal status, you can be deported or removed at will. And this is even before the story of the most recent Trump administration. And that doesn't even get to the point of having folks with long connections to the community engaging in essential forms of work that are also denied any meaningful political rights. So we don't even have a conversation about residential voting in the US. And to think, I think, more creatively about like, well, what should the goal be? My own view is that the folks that are part of our community should have a central role in making decisions about what that community consists in. And that's not something that's dependent on like the formal attribute of citizenship. And it's why, in many ways, I think of the project of immigrant freedom as the contemporary civil rights struggle that defines whether or not this country is a democracy. And as a way of just being like slightly hopeful in this moment of real pessimism and, despair and violence toward many folks that are part of our communities, it is also just the fact that the people that want to do the version that Bob was describing of taking us back to the national origin quotas from 1924, what they want is to effectively erase the 20th century, to go back before the massive cultural, social, demographic changes that took place. And I think, in a deep sense, that's tilting at windmills. There is no going back before the 20th century. We are a different country. We are Americans in a different polity with a different cultural community. And that no matter what the project might be of using, violence, the coercive apparatus of the security state to send us back to the 19th century, there is no erasing the 20th century. And that there's only the project of building this country together for the next one.
Thank you all. I mean, just to end it on a more lighthearted note, I hear a lot of the youth, joking around like, you can't if you want to kick out the immigrants, we gotta take back our food with us, right? You can't be going to Panda Express or to celebrate Taco Tuesdays and also and bring America back to like you said, it's erasing the 20th century. And so thank you all for this mini lecture. I think this has been really incredible. I hope everybody in the audience now goes and finds all of your books and literature to read more on they've just a drop in the ocean of what they've covered. I see a question from one of our OCA members on what are some of the pathways to remove some of these limitations and to more inclusiveness. I will actually save that question for our next panel. So if everybody here can make sure you tune in on Wednesday for part 2 of this webinar, Paperwork as Power, featuring Dr. Mei Ngai, Dr. Xiaojian Zhao, and Professor Natsu Taylor Saito this Wednesday, also at 8 p.m. Eastern, 5 p.m. Pacific. And we can talk about just continue building on this conversation and maybe address your question there, Elizabeth. So I want to thank our fall policy intern from WashU, Jordan Kim, for developing this webinar series and putting together a fantastic panel of speakers. Again, you can find this webinar on our YouTube later this week by just searching OCA National. I'm really grateful for the time, Hiroshi, Bob, and Aziz, that you've taken with us tonight. To our audience, thank you for tuning in. And with that, have a great evening. And you can find our webinar on our website, social media, and that's all I think. Have a good
Thanks
night,
to you for
everybody.
moderating.
Thank you all.
Thank you. Bye-bye.